Welcome to the Agent of Wealth podcast with Marc Bautis from Bautis Financial. In this podcast, Marc helps guide you towards financial freedom, ensure you never run out of money, and create a balance in life that prioritizes what is most important to you. Join us for this journey as Marc draws from years of expertise and guest experts to solve the multiple wealth building challenges involved in your financial life.
Welcome back to the Agent of Wealth. This is your host, Marc Bautis. On today's show, we're diving into a topic that isn't flashy. We're not going to talk about the latest IPO, and it's not about timing the real estate market. But I can tell you with 100% certainty that what we're discussing today can save your family hundreds of thousands of dollars, years of emotional distress, and potential legal warfare. We're talking about beneficiary designations. Now, I know what some of you might be thinking. I already have a will. I set up my trust. My estate planning's done. If that's what you're thinking right now, this is a great episode to listen to, because here's a hard truth that catches millions of Americans completely off guard. Your beneficiary designations almost always override your will. It doesn't matter if your last will and testament says with a notary and 3 witnesses that everything goes to your children. If your 401k or your life insurance policy lists someone else, that could be an ex-spouse, a deceased relative, or even left blank, the financial institution legally must hand that money over to the person named on the form. Your will cannot save you. Today, we're going to look at exactly how to conduct a total beneficiary audit of your life. And to ensure you understand the gravity of this, I'm going to share a couple of real-life estate planning horror stories where families lost everything because of a single forgotten form. Before we talk about how to audit your assets, let's talk about why this matters so urgently. As a financial advisor, I see the paperwork behind people's lives every single day. And unfortunately, I also see what happens when the paperwork gets neglected. Let's start with a scenario that happens far more often than you would think. It's the story of a man we'll call Robert. Robert was a successful corporate executive. Early in his career, in his late 20s, he got married to his first wife, corporate attorney Sarah. When Robert started his corporate job, he did what we all do on day one. He filled out a mountain of HR paperwork, including setting up his 401k and a company-provided $500,000 life insurance policy. Naturally, he named Sarah as his 100% primary beneficiary. Fast forward 7 years. The marriage didn't work out. They got divorced. It was amicable enough. They split the assets down the middle, signed a divorce decree stating that they waived any right to each other's future assets, and they moved on with their lives. A few years later, Robert met Linda. They got married, bought a house, had 2 beautiful children. Robert loved his family deeply. He went to an estate planning attorney and drafted a beautiful, rock-solid will. The will explicitly stated, upon my death, all of my worldly possessions, investments, and assets shall go to my loving wife, Linda, and if she passes, to my children. Robert felt great. He felt like the responsible husband and father. He put the will in a safe deposit box. 10 years later, tragic news hits. Robert suffers a sudden fatal heart attack at age 48. Linda's devastated. Amidst her immense grief, she has to figure out how to pay the mortgage, how to provide for their teenage kids. She calls Robert's HR department to claim his 401k, which had grown to $2 million over his career, and his $500,000 life insurance policy, for a total value of $2.5 million. But HR delivers a crushing blow. They tell Linda, "We're so sorry, but we cannot pay this money to you. The beneficiary on file is Sarah." Linda says, "No, you don't understand. They've been divorced for 15 years. I have the divorce decree right here. Plus, I have his final will that leaves everything to me." And this is where the law steps in, cold and unyielding. Robert's 401k was governed by a federal law called ERISA, the Employee Retirement Income Security Act. Under ERISA, a plan administrator must pay the beneficiary named in the plan documents, regardless of state divorce laws, regardless of divorce decrees, and completely regardless of what a personal will says. The case went to court. Linda spent thousands of dollars in legal fees trying to fight it, but the court had no choice. The $2.5 million went entirely to Sarah, the ex-wife from 15 years ago. Sarah legally was under no obligation to give a single penny to Linda or Robert's kids, and in this case, she didn't. Linda had to sell their family home just to get by, all because of a form Robert filled out in 20 seconds on his first day of work in his 20s and never looked at again. So let me give you one more quick horror story, this one involving siblings. So a client came to me after her brother passed away. Her brother was a lifelong bachelor, no kids. When he opened his first investment account decades ago, he named his mother as the primary beneficiary. Tragically, their mother passed away in 2018. The brother, deeply grieving, forgot to update the account. He assumed that since his mom was gone, his estate would just naturally go to his sister, who was his closest living relative and the executor of his will. When he passed away, because the primary beneficiary was deceased and had failed to name a contingent or secondary beneficiary, the account that was declared to have no valid beneficiary. So what that means is that the assets had to go through probate. And probate's the court supervised process of distributing a deceased person's estate. It took over 14 months, cost thousands of dollars in court fees and executor expenses, and because of old debts the brother owed, that could have been avoided if the money had bypassed probate directly to a beneficiary. Creditors chewed up a massive portion of that inheritance. These aren't isolated incidents. They happen every single day because people treat beneficiary designations as a set it and forget it chore. So, how do we make sure this never happens to you or your family? And what you need to do is perform what I call an annual beneficiary audit. And I tell my clients, tie this to a specific time of the year. Maybe it's tax season, maybe it's your birthday, or maybe it's right now. And to do this right, you have to look at how different types of assets flow when you pass away. Not all accounts are treated equally by the law. In basic estate flow, your estate is essentially split into two distinct pipelines when you die. You have the probate pipeline, which these are assets governed by your will, and then you have the direct pipeline, which these are assets that completely bypass your will and go directly to the named beneficiaries. So let's walk through how to audit every single asset you own, category by category. In the first category, we have employer sponsored retirement accounts. These are your 401ks, your 403bs, your TSPs. And this is a lot of times where the biggest dangers lurk, just like in that story from Robert that we heard earlier. Uh, the law here, it's governed by federal ERISA law. If you're married, federal law dictates that your spouse is automatically the 100% beneficiary of your 401k, unless your spouse signs a specific notarized waiver allowing you to name someone else. A lot of times, or a lot of examples, you'll see this is like children from a previous marriage. If you get divorced, that automatic protection disappears in some contexts, but remains trapped in others if you don't update the paperwork. So your action step here is log into your employer's HR portal or your 401k financial institution. Don't just look at the investment balance. Click on profile or beneficiaries. Physically read the names, check the spelling, ensure that there's both a primary and a contingent or secondary beneficiary that are listed there. In the second category, we have individual retirement accounts. These are your traditional IRAs, your Roth IRAs. Unlike 401ks, IRAs are governed by state law, not federal ERISA law. This means that spousal rules vary by state. If you live in a community property state, your spouse may legally own half of your IRA anyway, but you still must explicitly name them on the beneficiary form to avoid administrative nightmares. So your action step here is log into your custodian's portal, that's your Schwab's, Fidelity's, Vanguard's, and just verify the designations and make sure that your beneficiaries are listed and who you want them to be. Third category, we have life insurance policies. And these could be group or private personal policies. Life insurance is a private contract. It passes strictly according to contract law. So when people frequently, when they buy a policy, they usually, when a child's born, they name their spouse as the primary and they leave the contingent blank. If you or your spouse are in a car accident together, that money enters this nightmare zone of probate because there's no living primary beneficiary and no contingent beneficiary was listed. So action step is call your insurance broker or agent or check the online portal of your insurance policy and make sure you have clear contingent beneficiaries listed. All right, the last category is your taxable brokerage accounts and your bank accounts. By default, these go to probate or your will when you die, unless you add a specific legal designation. So for bank accounts, this is called your POD or payable on death. And for brokerage accounts, it's called the transfer on death or TOD. Your action step here is if you have an individual checking account or an individual brokerage account, ask your financial institution to add a TOD or POD designation. This turns a taxable account into an account that bypasses the probate court entirely, landing straight in the hands of your heirs within days of your passing. All right, so now that we know how to map out the assets, let's talk about three common traps that trip up even the most well-meaning people during a beneficiary audit. So the first one is naming minor children directly. I see this one all the time. A well-intentioned parent names their 8-year-old and then 10-year-old as contingent beneficiaries on $1 million life insurance policy. They think if something happens to me and my spouse, I want the kids to have the money. Here's the problem. Insurance companies and financial institutions can't legally cut a check to a minor. If you pass away while your children are minors, the court will step in. They'll appoint a legal guardian to oversee the money. This involves court costs, ongoing reporting, a judge deciding how your money's spent. Then the moment your child turns 18 or 21, depending upon what state they're in, they get a check for the entire amount. So think about that. A college freshman getting a lump sum check for hundreds of thousands of dollars with zero restrictions. Some kids I know can handle it, others maybe not. So the fix is, if you have minor children, talk to an estate planning attorney about either setting up a trust or utilizing a Uniform Transfer to Minors Act account designation, or naming a trusted adult as a custodian under the UTMA framework. All right, the second trap is the per stirpes versus the per capita blind spot. When you fill out a beneficiary form, you might see these weird Latin phrases, per stirpes and per capita. Most people ignore them, but they change everything if a tragedy hits your family tree. So here's what it means. Let's say you have two children, Chris and Jenny. You name them as 50-50 beneficiaries. Each of them has kids of their own, obviously your grandchildren. Tragically, Chris passes away before you do. If the form is set to per capita, which means by head, Chris's share is erased and 100% of the money goes entirely to Jenny. Chris's children, your grandkids, get absolutely nothing. If your form is set to per stirpes, which means by branch, Chris's 50% share flows directly to his children. So if your goal is to make sure your grandchildren are taken care of if one of your children predeceases you, you must ensure the forms specify per stirpes. And the third trap is forgetting to coordinate with your trust. So you've gone through the effort and expense, you've created a revocable living trust, you have this rock solid trust in place, but as a vehicle, but the vehicle can't drive you anywhere if you don't put gas in the tank. And in estate planning world, this means funding the trust. And actually, this happens more often than you would think it does. So if you have a trust designed to protect your assets, distribute them over time to your kids or whoever, you often need to name the trust itself as the beneficiary on your life insurance or your taxable accounts, rather than naming individuals. Just a quick note here, naming a trust as a beneficiary of a traditional retirement account like a 401k or an IRA gets complex due to the IRS RMD rules. So always sit down with your advisor or estate attorney before you do that. All right, so we've covered a lot of ground here. We looked at the tragic reality, what happens when old paperwork overrides your current intentions. We mapped out the differences between the probate pipeline and the direct beneficiary pipeline, and we broke down how to look at your accounts. So your homework, which hopefully you do now, is pretty straightforward. Take 30 minutes, whether it's this weekend, today, or soon. Open up a spreadsheet and a piece of paper. List every account you have, every old 401k from a past job, your current retirement plans, your life insurance policies, your bank accounts. Log in, check your primary and contingent beneficiaries, and verify that they match your life as it stands today in 2026, not how it stood 5, 10, 20 years ago. You may have gone through a divorce, had a marriage, had a child, lost a loved one. It's not just a good idea to do this, it's an absolute necessity. If you need help navigating, or if you want an expert set of eyes looking at or helping you with this beneficiary audit, that's exactly what we do. You can reach out through us to our website, bautisfinancial.com/call to schedule a session. I want to thank you for tuning in to today's episode of The Agent of Wealth. If you found value in today's episode, please hit the subscribe button, leave us a review, share the episode with a friend or family member who might need that gentle nudge to check their own paperwork, and hopefully tune into next week's episode. Don't forget to follow The Agent of Wealth on the platform you listen from and leave us a review of the show. We're currently accepting new clients, and if you'd like to schedule a one-on-one consultation with our advisors, please do so at bautisfinancial.com/call.
Thank you for listening to the Agent of Wealth podcast. Click the subscribe button below to be notified when new episodes become available. The information covered represents the views and opinions of the guests and does not necessarily represent the views or opinions of Bautis Financial. The content has been made available for informational and educational purposes only and is not intended to be a substitute for professional financial planning and investment advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investments and financial planning.